Thanks for joining us. We are here today at Fort Collins Startup Week with a exciting and riveting presentation that we are calling What? Why? How? Common Intellectual Property Questions and Answers for Startups. We have with us three tremendous experts when it comes to intellectual property and businesses. To talk to us about copyrights, trademarks, patents, what those are, why you need to know about them, how you go about protecting your important intellectual property, which for many startups is really the core of their business and should be valued and protected in a variety of ways. I'm Meredith Badler. I'm the Deputy Director at the Colorado Business Committee for the Arts, the CBCA. We offer many different programs and educational opportunities specifically for the creative industries. In particular, we run Colorado Attorneys for the Arts, or CAFTA, as well as offering numerous other webinars and educational resources for small businesses and individual creatives all over the state. And we have with us today three terrific panelists, Molly Kocialski with the Rocky Mountain U.S. Patent and Trademark Office, Dave Ratner with the Creative Law Network, and Nicole Rasu with the Sant'Angelo Law Offices. I'd like to give each of our panelists a chance to introduce themselves a little bit further, and then we'll dive into some content today. So Molly, how about you go ahead and go first?
Hi, everybody. I'm really sad that I can't join you in Fort Collins in person, but, you know, needs must, so we all adapt. I think that's just a human condition. So you're very familiar with me. I am the Regional Director of the Rocky Mountain U.S. Patent and Trademark Office. I was an in-house counsel on intellectual property issues for 3 different Fortune 200 companies in the Colorado area, and I've been in private practice. And so I've kind of done it all from an intellectual property perspective. I was in copyrights, trademarks, trade secrets, and patents from both a litigation and a prosecution perspective. So kind of that jack of all trades. And I'm very much looking forward to this conversation because I think it's going to be illuminating for all of you.
Thanks, Molly. Dave, why don't you go ahead and go next?
Hi, I'm Dave Ratner. I run the Creative Law Network. We are a law firm, and we focus on working with creative people and businesses. All sorts of intellectual property runs across the field for us, and we do work with a lot of startups. And we kind of are a startup. We're a boutique law firm, and work with a lot of folks that we run into just around the state. We, as Molly said, really enjoy being in Fort Collins in person. So this is definitely going to have to be a second best. But one thing we've realized in our work is we're helping businesses succeed, right? That's really what our job is. But the intellectual property rights that these businesses deal in are so crucial to that success that we find that it really becomes the focus of so much that we do. And that's one of the reasons we are happy to be able to put together this presentation.
Thanks, Dave. And Nicole, round us out.
Thank you. Hi, my name is Nicole Rasu. I am an attorney at Sant'Angelo Law Offices. I do all areas, kind of like Dave and Molly, that I work in patents, copyrights, trademarks, trade secrets, both procuring those intellectual property rights and enforcing them in litigation, et cetera. So we have, I love my job. I love being able to help others succeed and create new businesses and create new inventions, and it's just a wonderful thing for me to be able to help others. And this part of my reason for wanting to be involved in this wonderful presentation is to help educate those of you that are out there so that you know what to think about when it comes to IP rights and things you might not even know you have. You might already have rights that you came about automatically. So I look forward to this discussion and this panel.
Thanks, Nicole. Well, then let's dive right in. I think it's always helpful. Our first question is what? what the heck is intellectual property? We've already used a bunch of different terms just in our introductions, and so we'd like to take a moment to unpack those a little bit. So we have a handy-dandy visual aid here, and I'm going to ask each of our panelists to dive into certain aspects of this and give us sort of the quick and dirty 101 on some of these terms. So Nicole, let's start with you and talk a little bit about trademark. What the heck is a trademark?
Yeah, sure. So trademarks, I love the slides. We've got Google, and there's even a Coca-Cola and stuff. So trademark is a word or a symbol or phrase, sometimes even a color that distinguishes goods and services, the source of the goods and services from others. So if you've got, let's say, 2 cheeseburgers sitting in front of you, and one of them has a McDonald's wrapper and one of them has a Five Guys wrapper, well, you know exactly what you're going to get. You know the companies that make them, and so those are the trademarks: Five Guys, McDonald's, Google. The red sole of the Christian Louboutin women's high-heeled shoes, that's a trademark. So we see that shoe, someone wearing it, oh, I know exactly where they got that. I know the company that made it. I know the brand. So trademarks are all about branding and making sure that when your product or services are out there in the consumers for them to use, they know exactly who it's from and what it is. Trademarks can be established automatically, which is kind of cool, unlike patents. Once you start using a mark associated with your goods or services, you gain what's called common law rights in the areas that you have use. So let's say you have a lawn mowing company and you mow lawns all over Fort Collins and Denver and maybe up in Wyoming. Well, then you have use for the name of the company. Be creative with your name. So X, Y, and Z lawn mowing company has common law trademark rights everywhere they use it. And you can use a TM, that little super fit TM. You can use that automatically. You don't have to go and register anything. There is such a thing as going to get a federal U.S. registration where you do go and apply with the U.S. federal government, and they search your application and decide, hey, whether or not you do have a trademark. And if you pass certain requirements, then you get an issued registered trademark, and you can use a Circle R. And the benefit of doing that is now you have this presumption of use across the entire United States, which can help as your brand grows. And maybe you never had use in Washington, and now you have a registration. You can potentially prevent someone from using that name or mark in those other areas. Trademarks, as you can see, this is kind of a nice little cheat sheet for me, but trademarks can last forever. As long as you're still using the mark, they can last forever. They have no expiration. When you have them registered, there are some things that you have to do to keep them alive for the registered trademark, but it's a neat area. And trademarks are all around us. You've got them on, Google. I have a Yeti drink right here. They're all around us.
Nicole, do you want to touch on trade secret as well, just because it's also on our little sheet?
Sure, I'd love to. So trade secrets are another fun area of IP. Let me take a step back. So why do we even have IP? It's to protect your creativity. Why do we have these things? So one of them is a trademark, which we just talked about, this name or slogan or logo. We also have what's called a trade secret, which are things that give a benefit to a company, but it's something that's highly secretive, like the formulation for Coca-Cola, a certain way of putting together a biological reaction that no one else can find out, but it's certain things that are held very confidentially within a company, and maybe only a few people have access to that knowledge. You don't do anything actively with trade secrets. You don't go register them. That would kind of go against the foundation of what a trade secret is. You want to keep them confidential, but you do want to make sure that you hold them very confidential so that if someone were to go in and break into your locked cabinet and steal that formulation or list or what have you, then you can prove that you had a trade secret and hopefully go after them for misappropriation of your trade secret or stealing it, so that hopefully you can somehow recoup that lost asset. Trade secrets last for as long as they're confidential. So once it's out, it's done. The trade secret no longer is around.
Awesome. Thanks, Nicole. Yeah. Dave, we're going sort of backwards from the bottom up on our little document here. So Dave, talk to us about copyright. What the heck is a copyright?
Well, copyright is the intellectual property protection in a creative work. So all sorts of creative works, whether it be music, video, poetry, choreography, architecture, all are protected by copyright. Computer programs, code, the creative side of things. And what is really, there's similarities and differences to these other areas of intellectual property. But the copyright, if you own the copyright in a creative work, or any copyrighted work, that means you are the only person allowed to exploit that work. And exploit is a legal term. Exploit means to use the work, so to make copies of the work, to distribute those copies, to perform or display that copyrighted work, to create derivatives of that copyrighted work, so to create something based on the copyrighted work. If you write a book, you own the copyright in that book. You own the exclusive right to create a movie out of that book or a TV show out of that book, because those are derivatives. So the copyright ownership gives a lot of rights that are really important to creators. And in fact, the original reasoning for creating copyright protection is to encourage people to create. Since you get protection in your creative work, that would encourage you to make more of them, because you can hopefully profit off of those creative works. And that's the underlying reason we have copyright protection. And copyright protection is federal, so it is a federal right that you get by the creation of the work. But it's also important to think about who owns the work, because by default, a creator owns the copyright in the work they create. So if I write a book, like I said, I own that book. But if Nicole and I write a book together, then we are going to co-own that copyright together. If I write a book and I send the book to Nicole and say, hey, could you do some editing on this for me? Well, she contributed to my book. She edited it, so she's going to have some copyright ownership in it. So this becomes really important when we think about our creative process and who's involved in the creative process. Because for startups, we may have a bunch of people who may or may not actually be part of our business who may be contributing to the creation of a copyrighted work. You may have, perhaps you're just hiring someone to build a website. Well, the design behind that website is copyrightable, and that, who owns that? Does that web designer own it, or does the company own it? So it's important to make sure those things are clear, and copyright can only be transferred in writing. So when you hire that web designer to create your website, there needs to be a contract that says that that copyright has transferred to the company, or clarify that it remains with the web designer. So we want to have that sort of clarification as well. There's an exception to this rule. The rule that I said about, well, whoever creates it owns it, there's an exception. It's called work for hire. And this is also going to be relevant for a lot of startups and for companies, because if an employee is creating a copyrighted work within the scope of their employment, then it's what we call a work for hire. The employee was hired to create the work, and the company is going to own the work. This is important, we say, within the scope of your employment, because if someone is hired, let's say, to do code, someone's hired a coder, but they also create a design, they create the artwork that we're going to use. Well, was the creation of that artwork in the scope of their employment? Is that part of their job or not? So it seems real cut and dry, and that's always how we want it to seem, and then you'll end up realizing there's a lot of questions, which we'll get to discuss as we go on here. The other exception as far as work for hire goes is a work for hire can happen in a written contract, even if someone isn't an employee. So you can have a situation where we have a contract that says, well, this person is not an employee, but the creative work, the copyright they created, is still a work for hire. It's still going to be owned by the employer or the person who hired that creator. And copyright does have a set term. It has a length of time that the copyright protection lasts, but it's quite a long time. It's 70 years after the life of the author. So if I write that book today, the copyright in that book will exist for 70 years after my death. Seems like a long, I hope that's a long time from now. And that means that if someone, when I pass away, that copyright transfers to my estate. And if someone wants to make a movie out of that book 20, 30 years after my death, they still have to get those rights. So copyright is something really important to consider because it does last a long time and does have a lot of value for the businesses that are working within these fields.
Thanks, Dave. And lastly, Molly, talk to us about patents. We have two different types of patents on our handy-dandy chart here. What's a patent? What's the difference here? Why should we care?
Yeah, so patents, these are my favorite topics because we hook you with the copyright, protecting the expression of the idea, the trademark, protecting the source of the idea. Trade secret does protect the idea itself, but it has to remain confidential. And then we get to patents. And the quid pro quo for patents, of course, is that you actually tell people how to make and use your invention in order to get the patent. So, right, there's a definite tension between trade secret and patents that, in order to get a patent, you have to tell people about what your idea is and how it works. There's actually three kinds of patents. We only listed two on the slide. I don't know if we ran out of room or what, but there's plant patents, there's design patents, and there's utility patents. Plant patents protect asexually reproducing varietals of plants. I'm not sure that that's something that's really interesting, but if somebody is interested about that, please do call me. I'm more than happy to talk about it. Design patents protect the ornamental features of a device. So one of the reasons that we have the Coca-Cola bottles on this slide is that the Coca-Cola bottle actually started out as a design patent. That shape is ornamental in design. It started out as a design patent. Coca-Cola realized that that was actually acting as a source indicator, and then they filed a trademark application on it, and now it's protected by a U.S. trademark. So it's really that shape of an article of manufacture. We call it ornamental. I'm told every single time I use the word ornamental that I have to qualify that as being, that doesn't mean it has to be beautiful. It can be ugly. But if the shape is unique, you can do a design patent on that particular article of manufacture. And then there's the utility patent. The utility patent is the thing that protects how something works, right? It gets into the nuts and bolts of your manufacturing process. It gets into the nuts and bolts of how a particular tool might work, or what a particular software program might do. The copyright in a software program will protect the code as it's written. The patent on a software program will protect how it functions. So I think that's one of the things that you really want to consider is what form of intellectual property might be appropriate for you. Patents go through, especially utility patents, go through a pretty rigorous examination on whether or not it's appropriate subject matter, whether or not it's novel, and whether or not it's non-obvious, as well as whether or not it's clearly described. And we call that the written description requirement. Because again, like I said, if you want a patent, you have to teach others how to make and use your invention. So, and a utility patent is good for 20 years from the date of the filing. And there are, in the utility patent world, there are two types of applications. There's something called a non-provisional application. That's the application that actually gets reviewed and examined by a U.S. patent examiner. The provisional application acts as a placeholder, and it really just gives you a filing date and a serial number that may be important down the road. In 2013, the United States went from a first to invent system of patentability to a first to file system. And so when you get your application to the U.S. Patent and Trademark Office is a really big deal sometimes, especially if you're in a crowded space with lots of competitors. You want to be the first person to reach the U.S. Patent and Trademark Office with that invention. So that's kind of an overview of patents. I'm sure there's more to talk about, but that's kind of at least the 101 topic of it, as we're going to go into some more topics, I know.
Yes, we are. Lots more to keep covering here. So that's the basic, what are these? We're going to keep using these terms, trademark, patent, copyright, throughout this conversation. Okay, so those of you watching at home, now you know what these words are. Why? Why should you care? You probably have some inkling, otherwise you wouldn't have clicked this link or turned on this video. But there's probably more you should know about that. So why should startups in particular care about intellectual property and some of these various aspects of it? And to sort of break that down, we thought it might be helpful to talk in terms of different types of startup industries or businesses that you might be in. As you could imagine, some businesses, patent is super, super important to them. For others, maybe it is really their copyrighted creative material. For some, it might be a combination of all three of these. So we're going to dive into some of those industries. First, I'd love Nicole to talk, if you could talk a little bit specifically about software, technology, app development. That's a huge area for startup businesses, and they overlap many different areas of intellectual property. Why should those folks care about IP? What's most important for them?
Yes, absolutely. So this is an interesting area where I think potentially all four of the intellectual property types could apply. So one thing with intellectual property, which is good or bad, is that even if you don't really care about protecting your own stuff, you can still get into trouble by stepping on someone else's toes when you create a new product or a new software program or a new app. So you always want to at least know enough to ask the right question so that hopefully you're doing your best to make sure that you're able to get out there in the market and not get slammed with a cease and desist, and also to hopefully prevent others from being able to take your new ideas and your software and your app so that they can't, take it from you and use it as their own. So let's see, with software and app development, I'm going to kind of touch on something that Dave brought up. For startups, make sure that you've got a nice agreement with the people that you're working with so that the ownership of the intellectual property is nice and tidy. You want to make sure that if you've got someone coming in as an employee, that if they invent something, the company owns that. Or if it's they're writing code, just the company should own that. Or even a trade secret. If somebody comes up with something really cool, the company should own that, and they have to give that to the company. So that's just, I guess, first thing to consider on why caring about IP, because if you have an employee that says, oh, no, I invented that, so now I'm either co-owner or I own the whole thing, that gets messy and not a lot of fun to deal with. Let's see, with trademarks, kind of the same thing, come up with a creative name. I think Molly, in our earlier discussions of this, was saying every company should have a trademark. It's, my initial thing was about you need a brand. People need to know when they see the cell phone I'm trying to buy, oh, it's Apple. So I know exactly who they are. I know the company, and I know that if I see a Samsung phone, well, what's the differences there, and what do I like better about that? So trademarks are important when it comes to your app development and stuff. And big part with technology is patents. Patents are an interesting beast. Like Molly has said a little bit that you have an idea, you put it together. I've done my own software patent applications. One of the big things that is probably best when you come up with these ideas is to do some sort of search. See what else is out there. Is another app that's doing something similar? If it is it patented? So, if it is, what does the patent cover? Are you infringing? Can you get around it? What maybe is pending that's been published that someone else is trying to do, because you want to be careful about stepping on other people's toes. Welcome to the legal world, and welcome to patent law, in that no patent search is perfect, because when you file a patent application, it doesn't become public until it gets published. And that could be 18 months after it's filed. It could be several years down the road until it issues into a patent. So there's always a window of risk that someone else beat you to it, because we're in the first to file system, and you just have to be careful with it. I'll just mention, that I'm kind of just going all over the place, there is such thing as IP insurance. So for the tech people and the ones that are really in this, maybe more of the patent world, you can get insurance that can help defend if someone sues you, and maybe even go after and sue someone else. So insurance isn't perfect, we all know that, but just be aware that's out there. Food for thought. Let's see. I think that's going to be a good start. Let's kind of go forward, and then if there are any comments, I'll bring them in.
Yeah, you guys are all being very well behaved and giving each other their turns to talk. So
you're keeping us in line. So if you step away, the gloves come off.
All right, we'll see. Maybe we'll get rowdy by the end. Next up, I want to talk a little bit about creative businesses. That's the world we work in at CBCA and Colorado Attorneys for the Arts. We know there are lots of creative individuals and creative businesses in Fort Collins and all over Colorado. Dave, talk to us a little bit about what creative businesses should be thinking about in terms of their intellectual property.
Sure. I think it actually, as Nicole was saying, it really can be any of these intellectual property types depending on what the business is. Creative businesses, I think, is a pretty big tent. It can be something we would traditionally think of as creative as an art gallery or an artist who makes their business as art, but also is all sorts of photography and videography, graphic design, video game design. Even I see so many folks these days, they're doing podcasts, and a podcast is a creative business as well. I think what links these together is certainly the copyright aspect of it, just going back to what I was speaking of before, because whether you are creating a video for a client or whether or creating a podcast, the copyright does protect that thing that you've created. And I should also mention that a copyright doesn't protect the idea, it only protects the expression of that idea. So if you have a concept for a TV show, for example, you have this great idea for a new reality show. Well, there's no copyright in your idea for that reality show. It's only once you start filming episodes, those episodes are copyrighted. It's a really important distinction, especially when it comes to defending or acting to protect our copyrights. But as referring back to what Molly said earlier, that every company has a trademark, really it's true, and it's true for creative businesses. It's true for everything we're going to talk about today. That the trademark represents your business to the public, so people recognizing you and distinguishing you from competitors is really important. And the space you're in may or may not be a crowded space. I think if you are, we'll take the example of wedding photographers. There's a lot of wedding photographers out there. So perhaps having a catchy name, a catchy trademark is going to help you. But also, what's also going to help you as a photographer is your photographs. If you take good photographs, that's going to make for a good business, and there's a copyright protection in those photographs. It also, I'll keep riffing on this wedding photographer example, because there's going to be a need for clarity on who owns the creative work in your business. I can tell you when I got married, my wedding photographer that we hired said, he tried to explain copyright to me and explained that he was going to retain ownership of the copyrights in our wedding photographs, but he would grant us a license to use them on Facebook and in a wedding album and so forth. That sort of definition is really important. I work with graphic designers or web designers who say, I have this deal with this client. This is what they're paying me. This is what I'm creating. This is when I'm delivering it. Well, who's going to own it? Really important. All these terms are really important, but deciding who owns what, when it's delivered, what you're getting paid for it, are all those really important terms. And it's not necessarily, that may not be the intellectual property terms you're thinking of, but really the control and disposition of that IP, of that intellectual property, is going to be crucial to the success of a business. And I think that certainly because this spectrum of creative businesses is so broad, there isn't any one catch-all, there isn't any one formula that works for everybody. But I think what is really important for creative businesses, and I guess for all businesses, is to make sure to identify your intellectual property so we don't lose track of it, and more importantly, so that we protect it and ideally can profit from it. Again, these intellectual property laws are there to support businesses, and that goes, your trade secret. We can go back to the Coca-Cola example with the bottle. One of the most famous trade secrets out there is the recipe for Coca-Cola. Right? Nobody knows it, and that makes it a very valuable trade secret. And so your creative business, if you've got a special way of doing things, that is a valuable trade secret. Protecting that, and for example, with contracts with your employees, going back to what Nicole had said. So it's clear who owns what and who can do what with those things is going to be important to executing a successful business.
Thanks, Dave. And Molly, you're our pinch hitter at the end of this section for just sort of general startups. What else? Why else? Or if you want to emphasize something your colleague said, why else should startup businesses care about IP, and what aspects in particular?
Well, there was one thing that Dave said that struck me that I absolutely have to ask a question about. So you're telling me that for those reality shows, there isn't a script that's already written? Because I just got to say, I think that there is a script.
I'm not telling you it's real. I definitely didn't say that. Reality doesn't mean it's really happened. Or it wasn't scripted anyway.
I was going to say, and perhaps as a wedding photographer, how well you deal with those bridezillas is probably more important than anything else. I shouldn't make fun of them. It's the most important day in a woman's life, or any spouse's wife. I really think so. But I think really, right, as any small business that's starting out, I think the first thing that you need to do is to understand that intellectual property will affect you. It's not for the large companies. It's not for, it matters even if you're operating a food truck. Because at the end of the day, right, what you create and your pride in what you are offering to people is all part and parcel of that intellectual property. It's what you put behind it. And so whether it's a trade secret for your buffalo wing sauce, or whether it's, a mark like Schwing for the wings food truck that a couple from Buffalo, or who used to live in Buffalo, operate around the Capitol on some of those lovely Wednesdays when we could all gather in one space. It really matters that you think about these things and be aware of them. One of the things that I love about intellectual property is it forces you as a small business owner to think about where you want to be in 5 years. What does your business look like? What do you think you want to be doing in 5 years? And then talk to somebody, right? Get help. Educate yourself on the forms of intellectual property and what might apply to you. And then talk to people about, okay, this is what I need to do. This is where I want to be in 5 years. This is what this needs to look like. And don't automatically reject anything that you might hear from others, right? Because what works for one business from an intellectual property perspective may not work for you. And it may not be the path that you need to succeed. Consider, of course, in that, where I want to be 5 years from now. I always like to tell people to start with the end in mind. What's your goal with your business? Is it that you want to hand your business down to future generations? Is it that you want to be acquired so you can start up a new company? Is it, think about where you want to end up, because a lot of the business decisions that you're going to make about your intellectual property assets, and let's be clear, every single intellectual property decision is at its core a business decision. You are creating assets for your company that will be examined no matter what the end game is for you, right? If your end game is to create a business that's going to go on for generations, you've got to have some pretty strong intellectual property to make sure that you're able to protect that marketplace for those future generations. If your goal is to get acquired, you would have someone like me, or what I used to do, taking a look at every single intellectual property decision you've made over the course of your business to determine whether or not, and second guessing you, really. I mean, honestly, about all of that. So, right, think about where you want to be, educate yourself about what intellectual property might help get you there, and then take the steps necessary, right? Get help from the resources that we'll talk about a little bit later in the program, and really ask a lot of questions. Please don't believe everything that you hear on the internet. Dave knows that one of my favorite myths on the internet is that, you can take 10% of somebody else's copyrighted work and that doesn't constitute infringement. That is a myth.
Oh, I've heard 30%. You're 10
now.
I've
heard 10. Okay, I've heard 10.
That's good to know. The rumors are diversifying. Pretty cool. Okay.
Those are rumors. Don't operate
Very
your business off of rumors, please. Right? And so I really do think, right, ask questions. There are lots of resources that are out there. Educate yourself and really find the set of intellectual property assets that works for your business.
Thanks, Molly. That's great advice.
Information,
not advice. Thank you. Great information. And you're so right about not, looking around, asking for good help and guidance and information, and not believing everything you read online. We've talked a lot about protecting intellectual property, and I think the word registration has been batted around. I want to take a moment to talk a little bit about that process. We've mentioned how copyrighted works can be protected from the moment you lift your pen from the page, from the moment your trademark is out in the marketplace. But we do have a registration system in our country. I'm hoping you all and whoever wants to sort of dive in first can talk about what that means, why should you do it, where to go to figure out that process.
Well, I know Nicole talked about trademark registration briefly in our kind of 101 section, and I skipped over the copyright registration, so I will make sure to explain that also briefly, because it is a little confusing when we say you own the copyright as soon as you create it, or you own the trademark as soon as you use it, and yet we have this registration thing. The copyright registration is also federal through the U.S. Copyright Office, and you don't need to have a registration in order to own a copyright or to have nationwide rights to your copyright. The thing is, you need to have a registration to enforce your copyright. So basically, if in the very hopefully unlikely and certainly unfortunate event that someone were to infringe your copyright, which means to use it without your permission, you would need to have a registration in order to pursue that infringer in court. And that becomes important even if you need to threaten that you're going to pursue them in court, because that infringer may very well know if you don't have that registration, you can't come after me you can't come very far anyway. And there's more to it as far as the damages you can collect. Basically, if you have the registration, you can collect what are called statutory damages, which is up to $150,000 per infringing act. So it makes the $55 to $65 registration fee seem worthwhile. The Copyright Office, however, does take their time reviewing things because they get so many registrations. It can be quite a long process for them to review the application. So it's important to get the application in soon, and ideally you should be registering within 90 days of when you first publish the copyright, which is when it's first offered to the public, basically. There are other kind of intricacies to the copyright registration system, such as registering a group of copyrights, because that can be a way to be a little bit more economical. But the Copyright Office knows this and isn't eager to let you register a group of copyrights under one registration fee. So a lot of times we're working with our clients to figure out what is the best way to get the most registration protection most efficiently. So there are a lot of intricacies to the process, but it all goes through the U.S. Copyright Office.
Thanks, Dave. And then Molly, do you want to talk? We've already mentioned a little bit about trademark and patent, that registration process. Anything you want to add there?
So both of those registrations are done through the U.S. Patent and Trademark Office that I work for. I mean, shockingly, right? That's why you have me on the call. So yes, www.uspto.gov is where you can begin your journey. We highly recommend a trademark application. And again, in creating any asset for your business, you want to get the right people involved. You will hear that time and time and time again. And your intellectual property attorney is going to be that partner for you to help you through those processes. The trademark registration process consists of, picking out an international class of goods and services, selecting the mark, making sure perhaps that the mark isn't already in use. And an attorney can help you out with all of those types of things. The examination itself, it'll be picked up by a trademark examining attorney. It will be examined for something that we call likelihood of confusion. That has a lot of different factors. But if you have a strong mark that, really is unique for those class of goods and services, it should be relatively smooth sailing. And what I mean by a strong mark, there's different types of marks going from what we'll call generic to arbitrary or fanciful. In a generic mark, you might think of the burrito place as a generic mark for, fast Mexican food. And then, something that might be descriptive would be, Benny's Burritos. Presumably, you're going to get a burrito when you go to those two places, right? The U.S. Patent and Trademark Office would view both of those marks as inherently unregisterable, right? You would have to have some secondary factor of distinctiveness in order to be able to get those marks registered. When you get into suggestive or fanciful or arbitrary marks, that's where the USPTO deems those types of marks inherently registerable, right? Those are the ones that you should be filing and you should be getting a registration for. So something like Chipotle, right? Chipotle is a pepper that's used perhaps in Mexican food. And so, right, you might get a burrito, but you might get tacos. You might get nachos, right? You might get a whole bunch of different things at Chipotle. Arbitrary or fanciful, continuing on the Mexican food theme, and I really don't know why I'm talking about food right now because it's right after lunch, but it might be Qdoba. Qdoba doesn't mean anything in any language. Trust me, I've asked. And I think they would have told me, but it really doesn't. It was completely a made up word. And so while Qdoba spent a lot of money marketing in the early days to make sure that people knew what their trademark was about and what their brand was about, it has served them well because they have a very broad range of protection based on that arbitrary or fanciful mark. So when you're selecting your mark and you're working with an attorney to help select your mark, clear your mark, and get it on file with the U.S. Patent and Trademark Office, that's definitely something that you want to consider. The process for trademark examining is anywhere from 6 to 9 months, depending on the strength of your mark and how clear the area is. And then you will get a notice of publication. There will be a window where people can object to you owning that word for those goods and services. If you sail through that process without any oppositions, you can have a mark probably within a year, on average, I would say. We are busy at the U.S. Patent and Trademark Office. We get about over 600,000 trademark applications every year. We only issue about 300 and some odd thousand each year. That is kind of a 1-to-1 ratio. So that tells you that there are a lot of people who might not be doing all of the research on whether or not their mark is clear, whether or not they have a good mark, a strong mark, or whether there's, just something that they haven't done in the process. So that's the trademark side of the house. The patent side of the house, I think Nicole mentioned that it might not be published for, 18 months. Yeah, it doesn't. And there are ways of not publishing at all, depending on the technology that you're working in and whether or not you want a foreign file. That means for filing in other countries. But, you start your patent process with an application. It has to have a lot of different areas, including a set of claims and drawings and a specification that talks about how the invention works. It will get examined. We are working really hard to get our pendency down. We're pretty close to 14 months across all of the technologies, although it does vary by technology, to first office action. And then it can take a while longer depending on how much you have to argue with the examiner. I will tell you that your first office action on a patent is usually a rejection. Please don't view that as a rejection of you personally. We are not commenting on you as a person in that. Although I understand that you might have, your emotions are very tied up in this invention, especially if you're looking at starting a business around this. View that as an invitation to a conversation with the examiner to tell the examiner why your invention is unique. Because when an examiner rejects your patent application, they're saying, I found something in the prior art, which is basically every single published document and published patent application or patent in the world. I found something out there that seems really close to what you're doing. So when you get a rejection from the examiner, it's your opportunity to really explain why your idea is unique. And then the process can take up to 3 years depending on the technology. There are ways to speed it up, including a Track 1 application where you can get a utility patent within a year. That process is pretty screaming fast. You do have to pay to get to the front of the line, but it is pretty screaming fast. Again, on the patent side, we are also very busy. Upwards of 650,000 applications get filed every year, and we issue about 330,000 patents.
Wow.
So, yeah.
You guys are busy, Molly.
But it's awesome.
For sure. And I think, I know, Molly, you shared sort of your favorite copyright myths. I think there are probably myths out there or misunderstandings about how long some of these things take. I appreciate you all sort of sharing some of these average timelines for getting registrations or approvals. Nicole, do you have any other common mistakes, pitfalls, myths that you'd like to dispel for folks?
Yeah, definitely. I think I'm just going to go through, so a big thing that when I get a new client that really doesn't know anything about IP, especially maybe on the patent side, is they're like, yeah, I've had this invention, I've been using it for the past 2 years, and I want to get a patent on it. Well, unfortunately, with patents, like Molly said, it has to be something that's new. And so my biggest thing, pitfalls or mistakes, especially if there's something that could be under that patent realm, a utility or a design patent, keep it secret until you know what or if you want to do anything down the patent realm. Because once you disclose that idea, you offer it for sale, you sell it, you put it on a blog, then you have maybe hurt your chances for foreign patentability, and you might have started the time clock for filing a U.S. patent, which could give you a 1-year grace period. So big thing with patents and those types of inventions and coverage is keep it secret until you decide what you want to do or until you have something filed. With trademarks, the big thing with, coming up with a new name, it's so good to do a search. I have had so many clients with a cease and desist letter. It says, I have no idea. I didn't know that someone else had this mark registered. And have you done just a quick search, which you can do on your own, USPTO.gov. There's a link under trademarks. And I think there might even be a way to search, an explanation of how to search. Molly, you can chime in. But
there is. There definitely is, and there's a tutorial too.
Yeah, they have great tutorials. You guys have great tutorials. But if you had done a quick search, then you would have known, maybe I shouldn't do that for my art business. I need to pick a different name, and you would have avoided all of this mess.
Well, and let's be clear, Nicole. I mean, right, even for a restaurant business, to get a cease and desist letter is really expensive. You're going to be looking at changing the signs out front. You're going to be looking at changing all of your restaurant menus. You're going to be looking at a time frame where you have to change your advertising. All of those costs, when you consider what you've sunk into them initially, and then to have to redo them because you didn't do a trademark search that you can do online, like in the middle of the night. To me, that's just wasted money. So, definitely educate yourself about that and figure out how to do that.
I mean, I would also add to that, though, what you discussed earlier about the likelihood of confusion in the examination process. It's important for folks to understand it's not just whether there's an exact same trademark. It's any trademark that is likely to be confused with your trademark. So spelling it differently, there's this great trend right now where people spell things without the vowels, right? Like Boulder is BLDR. If you try and register BLDR and someone has Boulder, that's going to be a problem because it still sounds the same. So I have plenty of, piggybacking on what Nicole says, I have plenty of folks who come to us and say, I did my search and I didn't find anything. That's because you didn't find a direct hit, an exact match. That doesn't mean your application is going to sail right through. So there's another step to this process that's important to understand as well, looking for similar marks. Different spellings, different languages can all be really important.
Absolutely, as well as who the target audience might be.
Right, what the goods and services are, all of those. We're suddenly making this sound complicated, aren't we?
We are.
Sorry.
but it's true.
Yes, one last comment is for copyright, just don't copy other people's work. I mean, I feel like in social media, it's just happening all the time. So don't take someone's cute picture from their website and put it on yours. I mean, it sounds so silly saying it, but people do it.
I think what's interesting is when we talk about trademark and patent, we're saying it can't be anything similar. What's fascinating to an IP person is that you can actually have two similar copyrights as long as you didn't copy it. So if I write a haiku today, write a simple poem, and Molly goes home tonight and writes a haiku that is identical, but she never saw mine, it's not a copyright infringement. Copyright infringement requires not only the substantial similarity, but also the infringer having access to the original. So the one distinction with copyright is you can go create something. You don't have to search the internet to make sure that there's something, that you're not creating something similar. You just have to make sure in your creative process, you are not duplicating something you've seen or used elsewhere. There is a bit of copyright theory that there's nothing new under the sun. We hear these arguments in copyright infringements a lot. Molly doesn't like that argument.
No, because the commissioner for patents in like 18-something, maybe 63, the commissioner for patents actually said nothing new will be invented.
So he was wrong then, he's wrong now.
Exactly.
But I think that we don't remember that copyright is intended to encourage the creative process, just not allowing someone to profit off another's work. So I think that's important. I will gladly share the most common copyright registration myth I get, which is, if I mail it to myself, that's as good as a registration. This is very entirely untrue. However, you are supporting the Postal Service. There's nothing wrong with supporting the Postal Service, but it is not a copyright registration. And the process, again, is not that expensive for the copyright registration, but it does cost more than a stamp.
Yes, and I would say the same thing on the patent side. There is no such thing as a poor man's patent where you mail your patent application to yourself.
Right.
That doesn't work. If you want a patent or a U.S. registered trademark, it has to come from the U.S. Patent and Trademark Office. And we do send you things that are really pretty with ribbon covers on them and those kinds of things. So it's worth it, I think. But no, the poor man's patent drives me nuts too. Although do please support the U.S. Postal Service. I feel like I have to say that as my sister federal government agency.
I will also say this is a common problem that I find that I'm sure, Molly, you're very familiar with, Nicole as well, which is once you submit a trademark application, it is a public record. So your name and address is out there for anyone to find. You will undoubtedly receive something in the mail that looks like an invoice from some random, the U.S. Patent Company, something that is not the Patent and Trademark Office. And this alleged invoice will say, spend $500, $2,500, whatever it is, pay us now to protect or renew or continue your registration. And it is a scam. The Trademark Office will never send you an invoice. It is always, just kidding. This is not advice, but I can tell you they are scams.
No, and I will tell you, this is completely information. The U.S. Patent and Trademark Office does not send you invoices ever.
In fact, you never send anything in the mail for trademarks. I never get this.
We do not. Right? It's a fully electronic process.
Totally electronic.
Mm-hmm. But we will never send you an invoice. We presume that if you are using the U.S. Patent and Trademark System, if you have filed something with us, then you will know when and what fees are due. And if you miss those deadlines, we do hold it against you. I mean, we will abandon your mark, or we will abandon your patent application if you don't pay your fees on time. But we presume that you have learned enough about the process. We will never, ever, ever send you an invoice. So if you get something that looks like that, not only would I tell you is it's a scam, but I would actually also encourage you, if you go onto our website, there's a way for you to report that. And we have cooperated with, we have partnered with the Department of Justice, as well as various attorneys general around the nation to prosecute people who are doing that. And there's one particular prosecution that happened in California. I think these three gentlemen had ripped off intellectual property stakeholders, customers of the agency, to the tune of about $2.4 million. And so two of them were tried. One of them pled guilty and is serving a prison term. So, do know that we are aware that those things are going on. The U.S. Patent and Trademark Office is not an enforcement agency. We do not have the ability to prosecute ourselves, so we have to work with either a state attorneys general or the Department of Justice. So I want to put that out there, but thank you, Dave, for saying that, because it's a really important issue.
Wow. This is tricky waters. All right. Well, I want to go back to something that we were starting to touch on, which is also, unfortunate, is the conversation about infringement. What happens if you're infringed? What if you may or may not be the infringer? How do you know? What do you do? So maybe touch a little bit first, and again, anyone can sort of go first here, on what if you discover that someone else has potentially infringed your intellectual property. They're putting your artwork or your music on their product. They're doing something under your brand name. They're creating a product that you have patented. What do you do if it looks like someone is essentially infringing you?
So I'll go first, just to say, while especially your patent or your trademark or your copyright registration are publicly issued rights, right? Because they go through a federal government agency in order to be registered. It is your job to enforce. As the intellectual property owner, you might recall I just said the USPTO is not an enforcement agency. We have no ability to help enforce. We have no role. That's not our swim lane. And then I will also say, there's a really fine line between inspiration and infringement. So if you're in that space, like really do your due diligence. If you're creating things, know what's out there, and avoid it. And if you are being infringed, that might be a factor that you want to consider. But now I'm going to turn it over to the lawyers who do this way more than I do anymore.
I mean, I hate that this is not intended to be self-serving, but if you think you're being infringed, it is smart to contact an attorney. Yeah, because these things it is rarely black and white. There's a lot of gray area out there. Certainly sometimes there is a direct infringement. Someone has used your exact trademark for an exact same product or service. And even if that is the case, how to proceed, how to approach that infringer, you have options. Understanding what those options are and how they may play out, how they affect you, is really important. I think and my clients will say to me, hey, can I contact them first? Sure. That's one strategy is for the owner to contact them. Another strategy is for the attorney to contact them. What I always tell my clients is, it's like we hear on television. Everything you say can and will be used against you. So if you write that letter, and we later end up in court, that letter comes into court whether you intended it or not. And so we just want to be strategic, and I'll let Nicole kind of dig into some more details because I know she does this day in and day out.
No, I agree. Welcome to the legal world. It's gray, and trademarks, copyrights, patents they're not easy to always understand. The laws are constantly changing, and everybody's situation is different. So I think that it is very wise to talk with someone, an attorney, to at least understand your options. And there are such things as maybe, pick up the phone, or if you do wind up the owner themselves, with a little coaching from an attorney, hey, don't admit anything. Maybe you can have a nice conversation where nothing's admitted, but it's just a conversation. There are things such as a cease and desist letter that can be sent typically by the attorney. And even such things, like I've got some clients on Etsy, and they've taken upon themselves, this is prior to telling me, but there's these things called takedown notices that are kind of cool. I mean, they're on Etsy, Facebook, Instagram, I'm sure other social media and that kind of thing. But it's the way, if you have a trademark or a copyright, it's a pretty easy process. Like I said, one of my Etsy clients was able to take down a product from a competing company on Etsy, and it was pretty easy. So there are things that you can do that maybe aren't super extreme or hopefully don't get you into a lawsuit, that you can evaluate, hey, how do I move forward? But it's a complicated process, and unfortunately it's something that you have to police yourself. And I think it goes vice versa. If you get a letter, or, maybe you find out, oh my gosh, my trademark's just like this other person, I think it's best to talk to an attorney to at least understand the risks, the options, how to move forward, and hopefully how to walk away amicably without having to go into any big litigation.
Exactly.
Well, and I get that question fairly regularly, is this an infringement? And a couple things about that when I'm having that conversation with a client. One thing is to kind of, as I tell my client, to put themselves in the other person's shoes. And if you have a trademark and you think it might be close to another trademark owner, well, put yourself in the shoes of that other trademark owner. Would that person think it's an infringement? Would that person think it's unfair? And similarly, I get this with copyright a lot, where someone will say, well, I wrote this song. Is it too close to this other song? And I kind of say, well, what do you think? Because if you think it is, it very well may be. But there also are professionals, I'll use the music example, have musicologists, and their job is to compare songs and say, is this too similar? Musicologists know the copyright laws that apply to infringement and can apply those to do an analysis of one song versus another. I think it's important to understand, we're not up here trying to be self-serving. It's just that there's so much depth to this. There's so many years of court cases with precedent on this. There's so much detail and intricacy to these comparisons and these analyses that is just not, as going back to it not being black and white. I certainly am not trying to encourage people, let's spend a lot of time and money on this type of thing. We just want to have a successful business, right? And we do that by avoiding infringements.
And sometimes the answer is even, you might know you're being infringed, but, it may not be worth it from the societal or the optical perspective. And that's one of the reasons why you want to, really talk to, if you are being infringed or you think you might be infringing, the best practice is to contact an attorney and really be, very upfront and honest with them about that. But I know that there were situations when I was in my various roles before joining the government where my analysis was, we're being infringed upon, but we can't file suit. Like, right. we can't do this. The optics of this and how this will play out are just not going to work very well.
However, we also, right. But owners do have an obligation to defend.
You do.
So that's a balancing act. And again, this is something the average layperson wouldn't necessarily know about, but an owner has an obligation.
Right.
So it can be tricky. I will say the one more thing about the contacting an attorney is that my firm we always do a free consultation, right? And I think we see it as you have a right to knowledge, and we will share that knowledge. We can't provide legal advice, just like today we're not providing legal advice. But you're hiring a service. If you're engaging an attorney, in my opinion, you're hiring a service provider. You have a right to interview that person before you hire them. And so that's what we encourage at our firm. I don't know if you guys want to comment on that either. But
I will tell you that as well.
Yeah, I agree with that too. It's also, you have to make sure you can work well together, and absolutely, we do free consultations as well. Knowledge is power.
Lawyers shouldn't be scary. You shouldn't be afraid of us.
No.
We're all lawyers here, so I don't think we're scary. But no, I do. And I will say this is obviously from my pre government days, but I used to tell my clients, look, as your intellectual property lawyer, you're going to know me maybe longer than you're going to have other personal relationships. Seriously, when you're picking out a patent attorney, you're going to know that person for the next 3 to 5 years. Pick well.
Or longer.
and hopefully longer, right?
Right.
So pick well. But I will tell you that so if your idea of picking well is, maybe you have insomnia like I do and you watch the late night shows and, you see someone, we'll help you protect your invention, and it's on TV. But they don't give you the name of a lawyer and you can't really figure out who's behind that particular business. Be very careful in those situations. So especially on the patent side, every single person who is authorized to file patent applications in front of the U.S. Patent and Trademark Office is listed on our website at www.uspto.gov. Every single person who is a patent attorney was an engineer or a scientist before they went to law school. You can read a lot into a person's personality with those two factors associated with them, but one of them is not that they are shy. So if they are registered with the U.S. Patent and Trademark Office, definitely get a name, look that name up, make sure they're registered with the U.S. Patent and Trademark Office, and then I guarantee you that if they work for a law firm, they have a lovely website that talks about all of the different things that they have done. And again, they're not shy. So, find the person that works for you. If you're developing a new single-cell bacteria in a biotech application, you do not want me. I was a chemical engineer, and the only single-cell bacteria I work with is yeast when I'm making bread. So you wouldn't have wanted me as your patent attorney in that sense. You would have wanted somebody who also worked in biotech, maybe even somebody who majored in biology, right? Really look at the people that you're working with. Make sure that they are licensed to practice. And even on the Colorado attorney website, you can see whether or not any of us have had any grievances filed against us. Look people up and do your due diligence when you're selecting a partner. The same way you would if you were hiring a coder or if you're hiring somebody else to do work for you. Sorry, guys. That's just my little soapbox.
I agree with everything you said.
I agree too. Just a little. So I was a chemist, and I just passed the patent bar, and I'm a Colorado attorney. Just to make that clear.
See, I said not shy.
Should I say I was a band manager, and I can drive a 43-foot tour bus, and I've been in all 50 states, and I'm also an attorney.
These are all great points about, if someone is in the music industry working with an attorney who maybe knows that industry, if someone has sort of a chemical need going to a patent attorney who has a chemistry background, it makes sense, but it bears repeating to do this kind of research. And this is a great transition to really our last section here about resources. You are so not alone. You may be watching this video alone in your home, but you are not alone. There is a community of startup businesses, of business accelerators, of nonprofits, of government agencies that want you to succeed. So I'd love if we can just take a few moments and talk about some of those resources out there. Maybe, Molly, to have you go first and talk a little bit about what the PTO office has available and some of your other federal agencies from a government standpoint.
Absolutely. And I fully recognize how it sounds when a federal government official says, I'm here to help, especially in Colorado. So I'm going to say it, but I truly mean it. As my team knows, and even Dave and Nicole know, and Meredith, I adore this part of my job. And so if you need intellectual property information and you want to learn about it yourself, we have amazing tutorials on the website, www.uspto.gov. If you feel like you need to get a little bit more in depth, we have amazing training opportunities. And if you want to see what's being offered here in Denver, just go www.uspto.gov/Denver. And, really, honestly, and we've tried to think about all of our trainings from the stakeholder perspective so that, you can pull in, maybe at the point when you're ready for a search, you can attend our, search trainings or those types of things. If you want a little bit more of one-on-one time, absolutely. Call up my regional outreach officer, Julie Reavers. She will make sure that you get scheduled and we will have a conversation. I love helping businesses understand the world of intellectual property because it's a world I fell in love with 20 or more years ago, and I've never fallen out of love with it. It's just the most amazing place to be an attorney and to be able to help people. And so, you know, none of the information that the USPTO gives you is advice, but it is information. And you can take that information and then go talk to an attorney and see what works for your particular situation. So no matter where you are in the process, I mean, maybe you've already filed your application and you just want to know where it is or what's going to happen next. We're here for you, so please absolutely do that. Also check out if you need money, right? SBIR, STTR, some of the other SBA programs are SBDCs if you're a small business. In Colorado do an amazing job. You know, definitely reach out to all of them. If you are a minority-owned business, please reach out to the MBDA. There are also other things that go along with the Economic Development Agency or other agencies where perhaps there might be grants or money that's available. Obviously, the USPTO doesn't do any of that. We are a fully user fee-funded agency, so you pay us. We don't pay back out. So it's just kind of how it works. But seriously, and if you need introductions to any of those people, you know, our network, the USPTO's network, especially in Denver and in Colorado, is pretty extensive. So reach out, and if you need an introduction somewhere, we're more than happy to help.
Thanks, Molly. I know, Nicole, some of those that Molly mentioned are programs that I know you're familiar with as well as someone who's in Fort Collins, which is home of Innosphere and Techstars is up there. Do you want to talk about some of those sort of startup incubators or any other resources in that space?
Yeah, I mean, I definitely kudos to the USPTO.gov website. I think it is amazing in helping provide information. So I am all about Molly's promotion of that. It really does have some great information and videos and things that you can watch and learn from. Yes, there's Innosphere, these kind of incubators that help businesses grow, you know, depending on the technology or, you know, where you are in your business. If you're kind of in the middle or brand new, there's many different ways that you can reach out with these various companies. I have a client that has been extremely fortunate with the SBIR grants. I mean, they're really good at writing grants apparently, but I mean, it's great. It's money from the government. There's maybe a few caveats, but they don't have to pay it back. It's pretty cool. It helps their research and development, and how awesome is that? So there, again, are a ton of resources that we can all probably help connect you with in the event you're looking to enhance, get funding, that kind of thing. And I think just maybe taking a step back as a kind of a final overview, you know, these areas of intellectual property are here to create assets for you, and with those assets can help create your business. You know, if you've got a patent pending, well, maybe that is attractive for an investor here, and they're going to be more likely to be interested in your business to help you move forward because of these assets and because of the decisions that you've made as you have gone through the initial process and understanding IP. So there's just some really great stuff out there. You just have to know about it.
Yeah. Thanks, Nicole. And Dave, do you want to take a moment to talk about Colorado Attorneys for the Arts? That's a program we run through CBCA, but Dave has been an integral volunteer in launching and helping to run that program. If someone is actually looking for legal help.
I was going to say, all day we've been saying this is not legal advice. If you need legal advice, Colorado Attorneys for the Arts can help. CAFTA, Colorado Attorneys for the Arts, is the acronym, and it is coloradoattorneysforthearts.org. So CAFTA is what we call a Volunteer Lawyers for the Arts organization. And what CAFTA does is provide pro bono legal services to in-need artists and arts organizations. Pro bono means free. So for artists and arts organizations and arts businesses who who economically qualify for pro bono legal services, what the CAFTA does is you fill out an application that explains what your legal issue is. And if that qualifies for what CAFTA does, CAFTA will match you with an attorney who will provide pro bono legal services. So basically what CAFTA is a matching service. matching people in need with attorneys who can provide. And we really encourage everyone who is possibly interested, who may have a need, to check out the website and, if applicable, apply, because it really is a great resource that is essential to the creative industries. And we recognize the economic barriers to getting legal advice for lots of folks. And that's why CAFTA is there. CAFTA is there to help folks who might not otherwise afford an attorney to still be able to access that legal advice. So ColoradoAttorneysForTheArts.org. And Meredith I am integral in volunteering for Colorado Attorneys for the Arts. Meredith is integral in running Colorado Attorneys for the Arts, so she will be on hand to help you if that is something you need help with.
Yeah, when you send that email, it goes to me, goes to a person.
And Meredith, I'll just add in the pro bono program that's here in Colorado, ProboPat. It's run out of Mi Casa. If you need help getting the information, it's on our website, www.uspto.gov, but you can also find it on Mi Casa's website. They do an amazing job of helping pro bono inventors get their applications on file and get their inventions protected. They've got quite a few success stories. I'll just brag on Colorado a little bit here. The ProboPat program was literally the second pro bono patent program in the nation. And it's been operating, and it's been operating successfully since 2013. So I'm really proud of that program. They do an amazing job. It is, again, a matching service, but it is a way for under-resourced inventors to get some pro bono legal help.
That's awesome. Aren't you lucky to live in Colorado that you have both a pro bono patent and a pro bono creative business program here in our state?
Well, and I should say that if for some reason you're participating in Fort Collins Startup Week and you don't live in Colorado, your state may still have a volunteer lawyers for the arts or a pro bono patent program. So you can still, the internet is a beautiful, wonderful, terrible thing, and you can find what options are out there for you outside of Colorado.
Yes, there are so many people to help, and even sometimes in unexpected places. I know our public libraries often have business support services. If you are in Colorado and you are lucky to be located in one of our creative districts or near one of our small business development centers, there are so many people out there to help you. Other nonprofit organizations like ours. So with that, I think we have covered a lot of ground. I'd love just to go back around if there are any final thoughts or words of wisdom that our panelists would like to share. Maybe we'll go backwards from how we did our intros, and we'll start with you, Nicole. Any closing comments?
Just thanks for attending this. I hope that you got or acquired enough knowledge to at least know when to ask questions and know when to think about, oh, that might be something that could enhance, or maybe something we need to evaluate as maybe a problem. I am available if any of you ever have any questions. I think we all are. Please contact me. Just say, hey, I saw you on this Fort Collins Startup Week webinar, and I'd be happy to chat with you about any further questions or comments, or whatever we can do to help enhance your business and your next steps. Again, I said at the beginning that it's just a fun job. I think all of us, in being in the creative world, there's no other type of law I would ever practice. So it's just very fun to be able to help businesses and to see them grow and profit. And I thank everyone for their time.
Thanks, Nicole. Dave, how about you? Final thoughts?
I think that agree with everything Nicole said. The intellectual property, it's an asset. It's property. It is something you own. And just like you take care of your house or your car or other property you own, taking care of your intellectual property is really important. I think that is the one thing I would hope that folks would take away. I too am available, creativelawNetworks.com. It's an easy way to find me, and we always are really excited about supporting Startup Week and hope that there's a lot of great things that come out of it.
Thanks, Dave. Molly, wrap us up.
Can I just say ditto? No.
Sure.
Thank you for your time. Thank you for your attention. Please do not hesitate to get help. I know that that's sometimes the hardest thing to do, but don't hesitate to raise your hand. There are so many people who really do want to help. Start with this panel. Again, like Nicole said, just, say, hey, I saw you at FOCO Startup Week, so let's go. We'll dive right into it and get you the help that you need. So anyway, thank you so much.